Ms. Hany So.
Madam Deputy Speaker, thank you for allowing me to speak on this bill. I would first like to declare that I'm a practicing lawyer. As SPF's Rahayu has shared earlier, in Singapore, an accused person being charged with a capital offence will typically be offered free legal representations at trial and on appeal through the Supreme Court's Legal Assistance Scheme for Capital Offences, in short, LASCO, regardless of his or her nationality and regardless if one is of any means. The accused persons will then be assigned by the LASCO case assignment panel with a lead counsel with at least 7 years of legal practice who have represented parties in several capital trials and appeals before the Court of Appeal against conviction and trial, or acquittal. Second, an assisting counsel with at least 5 years of legal practice and have represented parties in capital trials, and sometimes also with a junior assisting counsel with experience in criminal trial and procedure. This team of assigned lawyers are expected to put forward the client's instructions to the best of their ability at the earliest opportunity, through making representations to the prosecutions in the hope that the charge can be reduced to a non-capital one. If unsuccessful, they will proceed to put up a strongest possible defense at trial. In the event that the trial judge is not with the defense and finds the accused to be guilty, deliberations will be made whether an appeal ought to be made against the conviction, on the basis that the trial judge might have either made an error of law or an error of fact in reaching his decision. As the procedure develops to this stage and beyond, you will often find that the defense case is evidentially weak and chances of succeeding becomes even slimmer. Whilst counsel might have advised the convicted person on this, the convicted persons may at times still insist and instruct his lawyers to explore further court proceedings options. Grasping at straws while prolonging their time away from facing the gallows, such futile exercises would invariably cause much time and resources to be wasted. Ordering of personal costs, as one member has suggested earlier, may be actually futile, as PACP, more often than not, comes with limited means. I therefore support this bill, which seeks to deal with post-appeal applications in a capital case with a prisoner awaiting capital punishment by introducing new procedures with enhanced safeguards for post-appeal applications. However, I wish to take this opportunity to seek the following clarifications. Firstly, in relation to legal representations. Typically, LASCO assignment will end in the event where mitigation has been made by counsel and sentence has already been given by the court, or when the case has been delisted from the Supreme Court. For example, when the prosecution eventually offers to reduce the charge to a non-capital one and be dealt with at the state court's jurisdiction instead, or when the presidential clemency has already been sought after the accused has been convicted of the capital offence. In this instance, would LASCO scheme be extended to cover applications for PACC permission and PACC, which may have occurred at a much later date after the presidential clemency has already been sought but rejected? The next question is in relation to whether 1, 3, or 5 Court of Appeal judges to decide on PACC matters. Pursuant to the new Section 60G, subsection 2 of the SCJA, the application for permission may be heard by a single judge exercising the CA's jurisdiction. The SCJA also empowers for such application be dealt with by 3 or any greater uneven number of judges sitting in the Court of Appeal. In this aspect, I wish to take this opportunity to seek the SPS clarifications. Under what circumstances would 1, 3, or even 5 CA judges be assigned to hear applications for permission to make PACC application, as well as for the PACC application? Whilst I understand the efficiency in getting just 1 Court of Appeal judge to hear and make a decision, we have witnessed on several occasions where landmark cases were made when CA judges have dissenting views amongst themselves. The fact that such application for PACC may constitute a last-ditch attempt to prevent a possibility of miscarriage of justice means it might be prudent to have at least 3 CA judges to hear such applications. Finally, in relation to the right to seek clarifications, in the event a single judge has been tasked to decide on the application for permission and/or for the PACC application, I understand from the new Section 60G subsection 8 and Section 60H subsection 6 of the SCGA that such applications may be summarily addressed without an oral hearing. In such situations, where the CA judge has refused the application, I hope that a substantive written decision will be given to explain the basis of the decision. I would also suggest that there be liberty for the PACP or his or her counsel to write in to seek clarifications and make further submissions to convince the judge otherwise. As per Lord Hewitt, the then Lord Chief Justice of England has once said, justice must not only be done, but must also seem to be done. Madam Deputy Speaker, notwithstanding my request for clarifications and suggestions, I stand in support of this bill.